Chapter 2, Necessity of a Study of the Common Law System, Sec. 3. Its study disparaged. Capable and learned men have disparaged the study of the common law system of pleading, as if the new system was independent of the old. Some argue that it is well to leave the logical processes of the common law in the schools, and that the business of the courts, we should adopt that line of pleading which practically subserves the furtherance of the cause of justice. Sec. 4. Two theories concerning the old system. According to Professor Pomeroy, two theories prevailed with reference to the effect of the code upon the old system. One theory was that the rules and doctrines of the common law and of equity still remain, although changed in many particulars by the reform legislation. The pleader must recur to them, and must then examine how far their requirements have been abrogated or altered by the statute. According to the other theory, these doctrines and rules of the common law and of equity do not exist at all as authoritative and controlling, that is, as controlling because of the common law or of equity. The general principles and fundamental requirements of the codes have been substituted in their place, completely abrogating them, and constituted by the legislature as the only sources to the bench and bar in shaping the details of the reformed procedure. If any particular doctrine or rule which formerly prevailed is also found existing today, it so exists not because it is a part of the common law or of the equity system, but because it is either expressly or impliedly contained in and enacted by the reformatory statute. It is perhaps safe to state that the latter theory, viz., that the code is the sole source of authority of the rules of pleading, is supported chiefly by the opinion of Mr. Pomeroy, the courts and the majority of writers holding that the codes abolished merely the forms of pleading prevailing under the old system, leaving the rules of substance which were dependent upon and so interwoven with the rules of substantive law that they could not be abolished without affecting the whole structure. Pomeroy states that the earlier cases adopt the first theory, holding that the common law rules were still applicable. Chapman, J., speaking of the Massachusetts Practice Act, said, "And though it changes the forms of pleading and dispenses with technicalities, it is still important in framing declarations and answers, so as to present causes properly for trial, that the principles of special pleading should be carefully regarded. There were certain essential and inherent distinctions and characteristic rules of pleading which were part and parcel of the rules and principles of substantive law, and which might be said to be beyond the power of the legislature to change. This may be illustrated by the inherent distinction between actions at law and suits in equity concededly beyond the legislative power to abolish. The general principles of pleading and practice applicable to the special form of common law actions apply as well to the forms of action prevailing under the Code. The Practice Act simply discarded the technical formalities of the common law. Sec. 5. Its study and intellectual training. R. Rossberry, author of an excellent work on common law pleading and an instructor in law, comments upon the advantage, in the way of training, gained by a study of special pleading. He observes, "The study of special pleading is not only essential to a correct understanding of the historical development of the common law, it is most admirable and essential as an intellectual training. No man can be a strong reasoner who does not possess natural or acquired logic. No man can be a strong lawyer who has not, in addition to this logic, a clear knowledge of the logic of the law, and special pleading is the logic of the law." He further says, "In addition to the general method of training given by this study, there is a particular advantage to be derived from it, notwithstanding the present abolition of special pleading and the substitution therefore of what is called code pleading. No code pleading can mar the beauty of pleading based upon the principles of the common law science. Just as natural logic lies at the basis of all clear and effective discussion upon general topics, so special pleading is the foundation of all legal discussion." Sec. 6. Comparative historical study of old and new procedure. An accurate and comprehensive knowledge of pleading cannot be obtained without first having made a thorough, comparative historical study of the old and the new procedure, the common law and the code, or of such parts of the old system as are useful to a proper conception of the new system. The knowledge thus obtained is of incalculable service in the practical application of the principles underlying the new system. Alexander Martin, Dean of Law Department of the University of State of Missouri, says, Authors of code procedure in the United States usually advise students commencing its study to first familiarize themselves with the principles of common law as well as equity procedure. As an instructor for 10 years in code, common law, and equity procedure, I have been impressed with the truth and propriety of this advice. I would not be understood as urging the student of code procedure to achieve that critical mastery of the common law system of procedure which was a necessary accomplishment of a successful English barrister, but that he should acquire such passable knowledge of its history and principles as will enable him to understand thoroughly the reformed system which has supplanted it. All the more necessary is such knowledge to the student of the modified system of common law procedure which prevails in some of the states. A general sketch of the system, or an exposition of some fragmentary parts of it would fail, in my judgment, to meet the requirements of higher education on this important branch of jurisprudence. The process of reasoning, in making comparison of the old and new systems of procedure, is like that adopted in the construction of a statute. In construing a statute, recourse must be had to the old statute, and the object to be obtained by the amended one. And so with the construction of a statute which abrogates or modifies common law rules, recourse must be had to the common law and a comparison made in order to ascertain the meaning of the statute. Our codes either repudiate or modify the common law procedure. We are able to better understand the code when, by a comparison between the common law and the code, the object of the change is made apparent. Again, a study of the common law system is necessary because we have not abrogated all of the rules prevailing thereunder. This course of study is not alone necessary and beneficial to the student, but knowledge of the principles thus acquired should be a familiar book to the well-educated practitioner. The lawyer who has thoroughly mastered the two systems of procedure will constantly find it of great practical advantage to him. A lawyer who is thoroughly familiar with the code, and who appreciates its spirit, must certainly recognize the reason and logic of the common law system. To become a good lawyer one must familiarize himself with the history of the law of procedure. One may succeed in practice though he may have a knowledge only of present methods, but he is far better equipped if he knows how and why the tools he is using came into existence. There is much useful knowledge gained by historical research. The eminent jurist, Judge Cooley, said, after a trial of the code system for many years its friends must confess that there is something more than mere form in the old system of pleading, and that the lawyer who has learned to state his case in a logical manner, after the rules laid down by Stephen and Gould, is better prepared to draw a pleading under the code which will stand the test on demurrer than the man who, without that training, undertakes to tell his story to the court as he might tell it to a neighbor, but who, never having accustomed himself to a strict and logical presentation of the precise facts which constitute the legal defense, is in danger of stating so much or so little, or of presenting the facts so inaccurately as to leave his rights in doubt on his own showing. Let the common law rules be mastered, and the work under the code will prove easy and simple, and it will speedily be seen that no time has been lost or labor wasted in coming to the new practice by the old road. The student, after having acquired knowledge of the old system, must then ascertain how much of the old system has been engrafted into the new, and then note the distinction. Professor Bliss' prefatory remarks in his Pleading are pertinent here. He says, "The law of pleading when following the common law mode of statement, commanded the earnest attention of every student. No one felt himself prepared to enter the threshold of the profession until he had mastered the subject, and to be a good pleader gave one an advantage and a rank among his fellows to be acquired by no other single accomplishment. But the new system has by so many been supposed to be so simple as to require no previous study. It is presumed that anyone can state the facts which constitute his cause of action in ordinary and concise language, and, with this idea young men rush to the bar without any intelligent conception of the multitude of questions involved in a statement of a cause of action, or in meeting such statement. They might learn something of forms, and would be compelled to under the old system, but logical conceptions connected with the substantive facts of each case involve something more than forms, and the power to grasp them seldom comes by nature. It is much easier for a person of dull comprehension to become a tolerably good pleader under the old custom than under the new. A study of the development of the system of pleading and procedure is interesting and instructive, and should not be neglected by anyone. The changes of procedure made from time to time as shown by history were rendered necessary by the development of substantive law which advanced to keep pace with the rapid strides of an enlightened civilization. Substantive law had to grow to keep up with the times, and if it could not be improved and molded into new form, or if new principles could not be established, through the forms of procedure in existence at the time, then it became necessary to repair the machinery of legal procedure. We may obtain as much useful information by a study of the imperfections and useless and senseless forms and fictions of the old procedure, comparing the same with the provisions of the code which took their place in the new system, as we can by pursuing a course of study of the logic and principles of reformed procedure, because such a course may explain the reasons for present enactments. However much we may codify the law into a series of seemingly self-sufficient propositions, these propositions will be but a phase in a continuous growth. To understand their scope fully, to know how they will be dealt with by judges trained in the past which the law embodies, we must ourselves know something of that past. The history of what the law has been is necessary to the knowledge of what the law is. An English lawyer, Montague Crackanthrope, in an address before the American Bar Association in 1896 said, "The English system of common law pleading was finally swept away by the English Judicature Act of 1873. It had been encumbered with obsolete learning, and had been terribly abused by the ingenuity of pleaders during centuries of adroit manipulation." The change was of enormous historical importance. The old system had been the mold upon which the whole common law had been gradually formed. All legal conceptions had been defined, analyzed, and formulated through the operation of that elaborate machinery. It provided a natural classification of the law, saving it from absolute chaos, so that students learned their principles as they went along, by mastering their procedure. Declarations, pleas, and demurrers have now become matters of antiquarian interest, as far as actual practice is concerned. But until the whole system of English law shall be recast and codified, the old learning respecting them will be indispensable to all who wish to be sound common lawyers. Without it a great deal of quite recent authority will remain obscure, and the old books in great measure unintelligible. Even in so simple a matter as an action of contract, it is necessary to know the peculiar and not unromantic history of the action of a sumpsit. In an action for injuries against a carrier we must still be familiar with the distinction between the breach of a duty to carry safely and a breach of a contract to carry, though we are no longer put to a choice between the one and the other form of action. And so long as written pleadings remain, the best masters of the art will be they who can inform the apparent license of the new system from a knowledge of the old.